So good morning, good afternoon, good evening, everybody. I know folks are still logging on. We expect quite a number of you this day, but I think we should get started so that we can stay more or less on time. Welcome back to day 2 of this conference on immigration policy in the Biden administration, the first 100 days and beyond. I'm Hiroshi Motomura, faculty co-director of the Center for Immigration Law and Policy here at the UCLA School of Law. So we have a great day planned for you, and in a few minutes, my faculty co-director, Ahilan Arulanantham, will give you a preview and set up some of the events and panels we have in our, of course, our midday conversation. But I'd just like to take a minute, a few minutes actually, to tell you a little bit more about the center and how this conference in the first 100 days fits into what we have planned for the rest of this year and beyond. And this is really both a look at the future, but also to give you some perspective on the conference that we have today and last Friday. And then, of course, we meet again a week from today for day 3 of this conference. So our focus in this conference is the immigration policy in the Biden administration. That's the moment we're in. It's a time of obviously major transition in the White House that's much more pronounced, drastic even in immigration policy than we've seen in our lifetime. But we also have a much broader ambition for our center, and I'd like to share a little bit about our priority areas for new initiatives. And I'm doing this partly to whet your appetite for what to expect from the center in the coming months, but also to suggest how this inaugural conference raises questions that we hope our future work will help to answer. So it's a bridge really from today and next week on into the future. And I'll say that one of the reasons we're doing this is because we want to get you involved in our work in various sorts of ways, input as audience, and in many different ways that we hope to create spaces to participate. So here are 3 of our major priority areas for our center. And these are samples, but I think they're indicative of the kind of ambition we have for the center going beyond this particular conference. One is a searching. I'll describe them briefly and say a little bit more about each. One's a searching examination of immigration law as a site of racism and race discrimination. The second is a rethinking of the role of state and local governments in the admission of immigrants to the United States. And the third priority area involves the relationship between the United States and the countries that migrants are leaving and the countries through which migrants travel en route to their destination. So let me just say a few words about these topics and how they fall from what we're doing in this conference. The first priority may not require much explanation at all, but I think it's worth elaborating a little bit on the description. It's the many ways in which race and racism and religious discrimination have found a perverse home in immigration and citizenship law. Of course, racial justice is one of the most powerful ideas of our time, but it's often understood as fairness within a bounded community inside national borders. But any hope for racial justice requires us to confront how borders can block the path to racial justice. If racial justice is only for citizens or only for people inside national boundaries, racial justice remains incomplete. So, and at the center in our first month, which was last month, we've done 2 things to address these issues, and when we plan more. But just to give you a sense of these examples, in late March, we filed an amicus brief in the United States Supreme Court on behalf of several scholars. At UCLA, our own law professor Ingrid Egley, at UCLA, also our history professor colleague Kelly Lyle Hernandez, and also Columbia University history professor May Nye. And this case, called U.S. versus Palomar Santiago, was argued in the Supreme Court several days ago. And it arose out of a federal prosecution for illegal reentry. And the point of our brief was to bring to light the troubling origins of this federal criminal statute. It was enacted first in the 1920s and then again in the 1950s, specifically to target Mexican immigrants because of fears that they would, quote, dilute, end quote, the white racial composition of the United States. So in addition, alongside actually, I was invited to testify before the House Judiciary Subcommittee on the Constitution, Civil Rights, and Civil Liberties at a hearing on discrimination against discrimination and violence against Asian Americans. And the core message that we had here is that the immigration laws in the United States had historically divided Americans by race and ethnicity, in particular by making it difficult or impossible for some US citizens in the United States to form families and communities. Our immigration laws have cast those citizens as less fully American and not belonging here. And in that way, our immigration laws have laid some of the foundation for violence against immigrant communities. This has been true in many episodes in the nation's history for Asian immigrants, for immigrants from Latin America, for Muslim immigrants, and for many, many others. So that is one thing that we are intent on working on in the coming months and years. Second area, I'll say a little bit about the second and third area, but a little more briefly, because it's areas that we have not had the time to quite get into, but to give you a preview of what's to come. Second area to tell you a little bit about involves the role of state and local governments in immigration law and policy. Of course, the traditional perspective on immigration citizenship is that these are areas of federal law, and that may be true in an ultimate and formal sense, but that still leaves a lot of time for state and local influence. It still leaves a lot of room for state and local influence. And that influence can cut in different directions, and that's clear from recent and distant US history. Many states and localities have tried to intensify immigration enforcement by the federal government, and many state and local governments have tried to limit or even neutralize federal immigration enforcement. And these are the areas that might come to mind when questions come up about state and local involvement in immigration law and policy, but there's more. And the center wants to think carefully about the state and local role, not just in enforcement, but also, and not just in the integration of immigrants, but we want to suggest ways to rethink the state and local role in influencing and even choosing which immigrants can come to the United States. If immigrants can revitalize neighborhoods and industries, what might be the role of state and local governments and economic sectors in shaping federal admissions policies? How might that lead to more constructive discussions if we were to shift immigration policy discussions to this new way of framing and making choices? A lot of questions here, a lot of questions we don't have the answers to, but that's what the center wants to engage in. And there's also one more area of center initiatives to tell you about briefly. This area, like the first two, calls for us to look into the future of immigration law and policy. Perhaps to a time when we no longer call it immigration law and policy. We're looking ahead to a time when we have new patterns of migration by people. It won't just be, quote, immigration, end quote, or emigration, but just migration, people moving. And this is the conversation that we need to have about why people leave their homes. They may feel they have no choice. The reason might be war, breakdown of civil society. It might be climate change leading to flooding or to drought. And what will it mean to say the United States or any other country that attracts migrants is addressing the conditions that force people to leave their homes? Is it a matter of sending development money to other countries, or how can we make sure that any such assistance really addresses dire conditions? And how do we make sure it's not just another way to build border walls? And what's the role of countries of transit, the countries that people travel through, for example, through Mexico to reach the southern border or the United States, or through the Balkans to get to Germany? And these scenes are repeated all around the world. And these are daunting questions about the new migration, but I think that we believe that answering them will help define the future of migration law. So this too is an area in which the center hopes to generate not just ideas, but ideas that can be put into practice. So I'm sorry I'm spoken so long about this. You might wonder if any of this will be on the final exam. I can assure you it won't, but we hope to engage in these questions. And I just wanted to give you a sense of some of the ambitions we have for the work for the Center for Immigration Law and Policy. I think that also that the other reason I mentioned this is, as I said at the outset, that these questions, what's the role of race, who shapes immigration law and policy, and what will immigration law and policy look like in the decades to come? They're all a way of understanding the topics for the panels in this conference. Even though they're focused on these first 100 days of the Biden administration, they also lay the foundation for our work in the months to years to come. And it's possible to think about it's impossible to think about questions of law enforcement, for example, or detention without thinking about race. It's impossible to think about the future of asylum, as we'll hear this afternoon, without thinking about the effects that climate change may have. So that's a brief preview, not just of the day and of the conference, but also of the center. And now I'd like to turn it over to my friend and colleague and faculty co-director, Ahilan Arulanantham, and he'll tell you a little bit more about what we have on tap for today. Thanks.
Thank you, Hiroshi. I'm Ahilan Arulanantham, the faculty co-director of the Center for Immigration Law and Policy. And I very much appreciated your summary of what's coming for the center in the time to come. But bringing us more to the present moment, I'm very, very excited for day 2 of this conference. For the next 15 minutes or so, I'm going to say a few things about day 1, recap, preview day 2, and then discuss some logistics in between. But before I do that, let me offer my heartfelt thanks to several people who have made this conference possible. The substantive, logistical, and communications challenges involved in this event have been daunting, and it takes a village to manage them. So many thanks to the following people for their contributions: Chris Newman, Shada Jalali, Laura Elbaum, Wei Joan Udden, Lynn Tremonti, Haley Burgess, Sophie Kosmacher, Christopher Roberts, Ashley Dominguez, Eric Green, and our interpreters, Daniel Tamayo, Daniela Guanipa, and Lorna Silva, for all their work to make today and the whole conference possible. We really, really do appreciate it. Now, as I mentioned last week, each day combines a morning panel about tactics and strategy, a lunchtime conversation with someone important to the immigration law and policy field, and then an afternoon panel on a substantive area. Now, day 1 was far too rich for me to even attempt a real recap, but I just want to pull out a few threads that I think stuck in my mind from the conversation. From our morning panel on The Infiltrators, which is a film about immigrant activists, undocumented youth who deliberately got themselves detained and put into detention centers in order to show that there were people with no criminal histories who were being held in immigration detention centers during the Obama administration. I mean, my primary recommendation is that you watch the film and then watch a recording of our discussion, which we'll be making available on the conference website. It really does give us all so much to think about. One theme that struck me was how advocates' views change over time. These radical activists depicted in The Infiltrators were arguing only for relief for people who have no criminal history, which today sounds very retro, as one of our panelists put it. And I wondered as I listened, what views do we hold today that will seem strange or retro 10 years from now, or will we circle back? I'm not sure I heard a clear answer to one central question the film raises in our present political moment, which is, should people engage in this type of civil disobedience now? And I think that reflects the difficulty of that decision. Claudio Rojas, Luis Nolasco, and others who so bravely organized from inside detention brought freedom to many, many people. But the human cost of that activism also hung heavy over us in the panel, as Claudio remained separated from his family, having been deported to Argentina in retaliation for his activism, and he appeared for the panel by Zoom from Argentina. Perhaps the clearest message came from Professor Alina Das. What should happen to Claudio and others targeted for speaking out about the Trump administration? Her answer was clear: bring them back. The lunchtime conversation between our own Professor Ingrid Egli and Cecilia Wong, the Deputy Legal Director of the ACLU, was also fascinating and equally impossible to summarize. Cecilia gave us a window into her thinking on litigation, how she structures her arguments in light of various imperatives, including the desire to further the immigrants' rights movement and the need to make winning arguments in court. She offered many insights from her efforts combating anti-immigrant racist policing in Arizona, which are still bearing fruit today, her work on excessive ICE detention, the Muslim ban, and so much more. The afternoon panel involved the immigration detention system, which everyone recognized as a form of incarceration. There was lots of productive disagreement amongst our speakers, but it was interesting to note the area of greatest agreement. No one would defend immigration detention in any form on public safety grounds, because even the so-called criminal aliens in ICE custody have come there after finishing their sentences in prison or jail. That being said, our panelists disagreed on a lot beyond that, including how much to focus on private detention as opposed to just detention generally, the human cost of closure campaigns that cause detainees to be transferred far from their families and their attorneys in many instances, and how anti-detention advocacy relates to the prison abolition movement. As with the morning, one takeaway for me was that tactical questions are hard, and there's plenty of room for disagreement among advocates in the immigrants' rights movement. All right, now before I get to today's events, I must again discuss logistics, and they're different from day one. And we have a lot of new people, so please bear with me. We are again using the Zoom webinar format, as you can see. So the only people you should see on the screen will be panelists, moderators, and occasionally people who are running the conference. You still only need the one Zoom link for the whole day, but unlike last week, the link will not remain open the whole day. Instead, we'll close it and bump everyone off at the end of each session. So you'll need to log back on at noon for the lunch session and again at 2 p.m. for the afternoon. To attend day 3 of the conference, which is next Friday, May 7th, you'll need to register separately for that day. Now you can do that on the conference website, and you'll get a new Zoom link when you register. For the morning and afternoon panels today, the Q&A is again open. So those of us working the conference will see your questions, but other registrants will not. During each session, some combination of the moderator and people running the conference will be reviewing those questions and trying to get them answered. Please don't be offended if your question does not get asked. We had nearly 700 registrants for today and currently have 215 people on here even right now, and I expect that will probably increase as the day goes on. Q&A is not open for the lunchtime session with Secretary Mayorkas. I'll explain more on that below. Chat is also unavailable in the sense that if you can't chat if you're an attendee, but if a chat shows in your box, it's probably a logistical message of some kind from the people running the conference. We have Spanish language interpretation available only for the lunchtime panel with Secretary Mayorkas. So far as we could tell, there was demand only for that panel. I hope we were right about that, and I apologize if we were not. My conversation with Secretary Mayorkas will be in English between the two of us. So if you want to hear it in English, you can ignore the interpreter button. Pero si quieres escuchar la conversación con el secretario Mayorkas en español, oprime al botón con el mundito, y elija español. And if you have any technical issues, please email us at cilp@law.ucla.edu, cilp@law.ucla.edu. We will be checking that during the events and can help deal with technical issues in real time. All right, now the good stuff. I said last time I would announce our day 3 guest, and here it is. At lunchtime in 1 week, Hiroshi will be in conversation with United States Senator Alex Padilla from the state of California. We are absolutely thrilled that Senator Padilla has agreed to speak with us. So please tune in 1 week from today for that conversation, along with 2 more excellent panels, one in the morning on tactics, on building power, and one in the afternoon on Congress, the president, and legal status. All right, and with that, we're on to day 2. Today should be fascinating in all 3 phases. Our morning discussion brings together organizers and attorneys to discuss movement lawyering. And if there's one thing we've learned over the last few decades, and as Cecilia Wong explained last week, most hard-fought changes to immigration law and policy, whether on the left or the right, were won through some combination of organizing and litigation. Yet the relationship between movement activists and litigators is often quite strained. So we bring together an experienced organizer at the forefront of the anti-enforcement movement, an organizer and lawyer leading African immigrant communities, and counsel for the class of all DACA recipients, and to discuss this important subject. That is going to be an amazing discussion, and I truly hope you'll enjoy it as much as I know I will. Over lunch, I will be speaking for an hour with arguably the most important single person in the field, in a sense. That would be the Secretary of the Department of Homeland Security, Alejandro Mayorkas. I cannot stress enough here how grateful I am to the Secretary for agreeing to come here and speak with me in this most public possible way. It's really something extraordinary and unusual for a government official to do something like this. We greatly, greatly appreciate it. In the interest of transparency, I want to disclose here that I shared in advance with the Secretary's staff the topics that I wanted to discuss in order to ensure that the Secretary would be prepared to give his best and most candid answers to my questions. I actually also even offered to provide at least some of the framing of the questions themselves, But they turned that down because they said they wanted to keep the discussion conversational and organic. We solicited questions from many people interested in this conference on Twitter and in prior panels and through other channels. And we were very fortunate to receive far more suggestions than we had time for. Ultimately, we chose to prioritize questions that were, one, particularly relevant to issues discussed in this conference and issues of sort of central import to the center, as Hiroshi had described our priorities in the morning, and two, on topics that I know something about. Because I thought if I'm talking to the secretary in this way, it would be important for me to be able to draw on my own background and experience to discuss the issues with him. And that necessarily means that we will not discuss many important topics. And I just wanted to list some of them here because I know there's a lot of interest in these. The metering of people seeking asylum at the border, the alleged forced labor practices in immigration detention, discrimination against Muslims throughout the immigration benefits adjudication system, which is an issue close to my heart. I've worked on it for a long period of time, and employment authorization delays for people in the H-4 visa category. All of these and several others, no doubt, warrant discussion, and I'm sorry, both about the time constraints and also the limitations of my own knowledge. One thing I have learned is that I still have so much to learn about immigration law. So what will we discuss? Here are the topics that I gave to the Secretary's staff: the border expulsion policy under Title 42, legal representation for children facing deportation, the treatment of immigrant activists, race discrimination in immigration enforcement, sanctuary city policy, which the Secretary had spoken about somewhat recently, the Secretary's vision for immigration detention reform, and temporary protected status. Obviously, it's a full list. I'm not sure if I'll get to all of that, I'll do my best. But those are the topics that we hope to discuss with the Secretary today. But please don't go away after the conversation with Secretary Mayorkas. Honestly, please do not, because the afternoon panel will be superb. There, we focus on the short and long-term future of asylum policy, which necessarily requires a deep dive into what's happening at the border. And of course, there'll be then sort of very obvious connections between the discussion that I have with Secretary Mayorkas and what we see in the panel that immediately follows. And again, we have three spectacular leaders in the field: an advocate routinely on the border who assists detained immigrants, a litigator who works on both sides of the border representing asylum seekers, and one of the academic leaders in the field who recently co-wrote a book titled The End of Asylum, which seems a very important and telling title for the panel. So it should be an absolutely fascinating day. I'm wondering now, it's 9:56. I think maybe if all the panelists are on deck, maybe I should just go ahead. Give me one moment just to look in our own discussion here and see if that's the best thing to do. Yeah, I think I'm going to go ahead and introduce our moderator for the next panel, unless anybody has any concern with that. We'll give them a little. I mean, it's a very rich discussion. Give them a little bit extra time. All right, I'm going to go ahead and do that then. So, if Samir Asher is on deck, I'm going to introduce you now. To kick us off, I'm going to turn things over to my good friend, Professor Samir Asher. Samir is a clinical professor at UC Irvine School of Law. And for more than 20 years, Professor Asher has worked with students to defend immigrants facing deportation, as well as other vulnerable populations. Samir and I first met a long time ago in New York in the days after 9/11, when we both worked to free people arrested in mass raids, sometimes called the Ashcroft raids, that occurred in the first few months following the attacks in the New York and New Jersey area. I think that was a formative experience for both of us because the raids targeted people primarily from South Asia, the Middle East, and North Africa, meaning people who looked like us. 20 years later, while Samir was at UCLA, he played an important role in the development of this center. And I'm truly grateful to you, Samir, for your role in making it possible for me to come here. Professor Asher writes about law, lawyering, and social movements across multiple subject areas, including immigration law. And the focus of his scholarship is on how law and lawyering both inhibit and enable collective action against racial and economic subordination. That focus, coupled with his deep experience in practice, makes him particularly well-suited to moderating this panel. Samir, take us away.
Thank you, Ahilan, and thank you, Hiroshi, for both of you for inviting me to moderate this excellent panel. If I can ask the panelists, Muneer Ahmad and Jacinta Gonzalez, to please put their cameras on. And we will be joined by Imaha Casa momentarily. I just wanted to set up the discussion for very briefly and let you know what our agenda is, what we intend to do, how we're gonna, how this exchange we hope will unfold. So it's pretty clear that there are a certain set of modalities of advocacy in immigrant rights work, including obviously individual deportation defense, as well as impact litigation and policy advocacy. The question that we are going to be probing at in this panel is how each modality can be undertaken either conventionally under conservative legal ethical constraints or less conventionally and necessarily informed by social movements. So really, this discussion is a discussion about tactics that advocates will take in the Biden administration, have already taken, and will continue to take in the Biden administration. More expansively, it's also about the development of cadres of lawyers and law students who may be embedded and acting within democratized movement spaces, as opposed to the context for a lot of advocacy and immigrant rights work in the past. We think that there's been a significant change that we will note in the course of this discussion, and we will discuss the complexities of. Okay, so the way we together, the four of us have structured this discussion is basically in four parts. First, focused on the rise of movements in immigrant advocacy work. Second, on the role of lawyers within movement-led advocacy in the immigrant rights context. Third is movement ideation, that is the generation of policy ideas from movement spaces and how that's a challenge to established norms within immigrant rights advocacy in the past. And fourth is the education, training, nurturing, fostering of new generations of movement lawyers to sort of to continue this work. I'm so pleased to be joined by these three amazing panelists, each of whom I admire and have admired before I met them. Well, for two of them at least. One I've known for many years. The first is Muneer Ahmad. He is the Deputy Dean for Experiential Education and Clinical Professor of Law at Yale Law School. For 2 decades, Muneer has represented immigrants active in social justice movements, including most recently in defense of the DACA program. And so we're pleased to have Muneer with us. We're also joined by Imaha Casa, who is the founder and executive director of African Communities Together. He's a lawyer with deep experience in organizing immigrant communities for social justice and was heavily involved in organizing Sudanese immigrants to protect TPS litigation that he engaged in with Ahilan when Ahilan was at the ACLU of Southern California. And we're also joined by Jacinta Gonzalez, who is field director of Mi Gente, a digital and grassroots hub for Latinx and Chicanx movement building and organizing. She's an experienced organizer who's worked on many campaigns, including most recently the Eyes on ICE Truth and Accountability forums that's shedding light on current DHS practices. I also know her to be a mentor of young organizers around the country, including in the place that I work in Orange County. And so really great to have Jacinta on this panel. We are going to be reserving time for a Q&A, so please submit your questions in the Q&A. I will attempt to cluster questions and pose them to the panel at the closing of our program, our kind of preset program. Okay, I'm going to ask a set of questions, and then I'm going to hand it over to the panel I'm going to be as non-interventionist in their discussion as possible, because again, it's three brilliant people with great experience. And so part one, the development of immigrant rights movement activism. The 8 years of the Obama administration was a particularly fertile period for the development of movement organizations in immigration law and policy for a complex set of reasons, in part based on a critique of established immigration advocates in Washington, D.C. Two of you work with organizations that you founded or co-founded in just the last 10 years. How might each of you describe the rise of social movements in immigrant advocacy, and what are some exemplary campaigns that you might offer to the audience that best demonstrate the shift from elite and lawyer-driven advocacy to a more grassroots orientation? And feel free to challenge the premises of the question as well. I'm going to start with Jacinta, and then we'll go to Imaha, and then to Muneer. Jacinta.
Thank you so much, and thank you for having me. It's really wonderful to be able to be part of this conversation. You know, I think to answer your question, Samir, I've been organizing in immigrant rights now under 4 presidents, right? So Bush, Obama, you know, Trump, we have to call him, and now Biden. And I remember when I first started as a young organizer, the advice that all lawyers would give us as organizers was make sure that people don't talk about their immigration status, right? It's too risky for folks to publicly talk about their status. They shouldn't say what country they're from. This is their best line of defense from being able to protect themselves from immigration authorities. And I just sort of say that because to me, it was actually very formative as a young organizer to be told, like, this is the way that you have to work with people. This is the way that you don't put people at risk. In a couple of years, that was pretty much shattered because of organizing that was happening in the undocumented youth movement, right? It was actually undocumented youth that were saying, we have to come out of the shadows. We have to talk publicly about our status. We have to use our stories as a way of building political power to get what our community needs in this political moment. And that was really, really transformational for a lot of things, including the way that we thought about how we built power and who was in the driver's seat. So when I think about, about like what was the formation of how groups were being formed, for example, under Bush, a lot of leadership was lawyers. A lot of leadership was also white people. And there was sort of this protective, paternalistic, let's figure out how we can figure out how to create a pathway to citizenship through, Congress for, folks that need it. And so once you start to have undocumented youth come out of the shadows, start to break that open, it changes a lot of power dynamics, but it also changes what's possible and who's considered a protagonist in the fight. And there's a huge challenge to what are the tactics, what are the strategies, what does this look like? And I can say for myself, I was organizing day laborers in New Orleans, kind of watching this from afar, it really put everything on its head in terms of how we approach strategies, to then actually be much more explicit around talking around deportations, talking around enforcement, talking around the collaboration that was happening between police departments and ICE, and actually calling out both the police and ICE, and not saying we need good cops to protect us, but actually racist police officers are working with racist ICE agents, and we need to be able to call that out collectively. And so I think that has really sort of transformed. And for me, a lot of the way that I think about the current immigrant rights movement was like the Not One More campaign, where folks across the country were participating in deportation defense, not because we wanted to, but because we had to, right? I think particularly under the Obama administration, seeing the huge increase in deportations that I would also say many advocates thought would be good for immigration reform because it was considered a trade-off, right? If we have more deportations, if we look stronger at the border, then maybe there will be more political space to pass something in Congress, but who actually paid the political price of that were directly impacted communities. And those were the folks that were fighting back. And, I remember the first moment that I had someone who was like undocumented, had been working in deportation proceedings, tell me that I didn't need a lawyer to help someone who was facing deportation, and that we could do it through organizing, and that I could write the letter, and that you actually didn't need to know all of the things that were taught in law school. And that just really reshaped the way we thought about how to organize and how to use community power to be able to push back politically in ways that were different than how attorneys would say. And to me, this is just like, it's important for folks to know also in terms of just like where we're at, right? The fact that we have movements that will say abolish ICE is actually coming from a really long history of folks that have been targeted by these agencies speaking out against them. The fact that we now can be thinking about, how to actually craft platforms of what we want to see in Congress that don't require these types of trade-offs and adding enforcement is also coming from all of those organizers that believe that this is a political possibility and have demanded it as such through their organizing. And so I think we're in a very different moment now in terms of what the immigrant rights movement looks like, what we're asking for, how we're fighting together. But I do just want to like kind of pose this question particularly to law students, which is like, sometimes the soundest legal advice is not the best advice for movements, right? It's not the best advice for how we create change. It might be true that for one person, not speaking about their status might be the thing that protects them the most. But when we actually think about collective liberation, it might actually get in the way. And so these are the types of questions I think that we have to grapple with as organizers and legal practitioners about how we figure out how to like, come to the middle point in terms of how we organize in a way that actually increases possibilities as opposed to limiting them.
Thanks, Jacinta. Amaha, do you want to weigh in?
Sure. So I think just building on some of the points that Jacinta sketched out, I think a lot of us who do go to law school, do so motivated by a desire for social change, right? Whether we do so, sort of right out of undergrad and, sort of without a lot of experience in social movements, or, as was my case, after having worked as an organizer in social movements and sort of seeing like, okay, this is how much change we're able to make. The lawyers play a really important role in concretizing that change. And sort of, I want to be not necessarily, I want to be an organizer who thinks like a lawyer, or a lawyer who thinks like an organizer. And I think we learn, almost from day one in law school that that the law is a very blunt instrument for trying to create broad social change. Sort of by design in many cases, right? It's, a legal case is designed to advance a particular case or controversy, right? It's structured around two parties and reaching a resolution. And we're trained as lawyers that our duty is to individual clients and to reach the best resolution possible for them. And even when we're doing sort of class action type things, it can be very hard to use the law to make broader social and systemic change. Now, it's obviously possible, but it's not necessarily sort of well suited to do so. But I think what we have to watch out for as lawyers is sort of concluding from that. Those two spheres are totally separate, and not confusing the fact that law is not a sufficient instrument to create broad social change with the idea that it's not necessary to creating broad social change. And the way that we get beyond this dynamic is in some ways by with litigation strategies and policy strategies being connected and tied organically to grassroots organizing, to policy campaigns, to leadership development and power building, and recognizing that actually when movements, as we've seen with the immigrant rights movement, as we've seen this past, just about a year ago with the largest uprisings in recent history happening around the movement for Black liberation, movement for Black lives, and being in the streets, that what is politically possible, what is legally possible, the parameters that kind of constrain our imagination as lawyers and attorneys can change like that as a result to broad-based social change. And our part of our duty is then to figure out how to be a force multiplier to organizers and to social movements to actually get that change done, as opposed to being a kind of like a harness to say, no, you can't do that. That's not possible. And I think sometimes that means that we as lawyers have to set aside our ideas about what is a good case or a good, a good legal fight to get into. So we were part of 4 different national lawsuits against the Trump administration. The Ramos v. Nielsen, which we worked on with Ahilan, African Communities Together versus Trump, which was our litigation over Liberians who were losing deferred and forced departure. La Clinica, which was one of the national public charge cases, and a case that we helped bring around the diversity visa with Georgetown Institute for Constitutional Advocacy and Protection. And we really struggled to find attorneys to take some of those cases because they were not, quote unquote, a good case. And I think the Liberian DED example jumps out. We got turned down by a lot of the large national civil rights organizations, basically saying, we think that this is a legal long shot. We don't think it's possible. For ourselves, working with the Liberian DED holders on DocuBlack Network, who we partnered with on the case, we didn't have a choice to walk away from those several thousand Liberian immigrants who are going to be losing their status. So we needed to find a way to do it. And of course, we understood that we had to do this as part of a comprehensive political and policy strategy, because we weren't going to win it straight up in court. But we needed a legal institution to partner with us on that. Luckily, we were able to find that in Lawyers Committee for Civil Rights. And the litigation that we did there is what preserved status for thousands of Liberians with deferred and forced departure, and ultimately laid the groundwork for us to go forward and win the Liberian Refugee Immigration Fairness Program, which was sort of unprecedented expansion under the Trump administration of access to citizenship for up to 10,000 Liberians, undocumented Liberians currently in this country. Wouldn't have happened without the lawsuit, and the lawsuit wouldn't have happened without somebody willing to be a movement lawyer and say, we'll take a risk. We may not win this in court, but we're confident that we can partner together and win it at the end of the day.
Muneer?
Yeah, thanks. So first of all, thank you for having me as part of this conversation. I'm really delighted to be in conversation with Jacinta and Ama and with you, Samir. I mostly want to maybe just pick up on some strands of the conversation that Jacinta and Ama have already kind of laid out on the table. And maybe to start with something that Jacinta said at the beginning about how the movement has changed, who populates the movement, and who has agency in the movement. And one way that we might think about it is the movement for immigrant rights has shifted from being kind of a concern for largely a liberal set of politically minded or activist minded people to a movement of immigrants for immigrant justice. Not exclusively so. There's a huge role for allies of various kinds, and the politics are complicated with lots of different stakeholders. But it is very different if you think back to when the last, what we think of as kind of the last major comprehensive immigration reform happened in 1986, and you look at who the constellation of actors were that brought that about. It didn't look anything like the people who are making movement happen today. And so that's a really significant change. It changes, again, as Jacinta said, it changes the narrative. It changes the sense of possibility. It changes the political parameters for conversation, because we're no longer locked in from the very outset of the conversation to what can get 60 votes in Congress, in the Senate. There's a different kind of sense of what is the realm of the possible, which is informed by an experience of injustice rather than jumping immediately to the constraints of deal making in Congress. I hasten to add that I think of it as being a movement of that's driven by immigrants for immigrant justice, where it's not immigrants for immigrants, it's for immigrant justice. And I think we should come back and talk a little bit more about how even the conception of immigrant justice has changed over time. That's something that's I think there's a very clear example of that among the immigrant youth movement, for example, moving from a movement that was very specifically about a version of a DREAM Act to being a much more expansive, visionary commitment to immigrant and racial justice. But I think that that's just one illustration, actually, of the ways in which many different elements of the immigrants' rights movement has expanded its own notion of what constitutes justice. And it's a notion of justice that is, to a very significant extent, focused on the rights of non-citizens, but actually is continuous with the rights of citizens because of things like the operation of race, for example. So again, themes that we might come back to. I think just to pick up on something that Ahmad raised, and maybe then bring this kind of to a resting place, this notion of what counts as a good case and who decides what is a good case, I think it implicates a question for us as lawyers as to what our intake is. So how do we decide which cases we take on? And the question of intake can feel somewhat mechanical. Do we have a hotline? Do we have a referral system? Do we go out into the community? It may feel kind of just procedural in that sense. But actually, as people like Susan Carl and others have written about, the question of intake is an ethical question. It's a question of allocation of resources, and it's also a values question. Where do we think change needs to be made, and who do we think makes change? Which is to say, where are we going to put our scarce and rare and elite resources? In whose service will we put them? That in turn implicates a question of what is our theory of change. And so I think for movement lawyers, there is an understanding, or there's a commitment, I should say, to the idea that the principal theory of change is movement-based and power building based. And if that's the starting point, well, then the intake questions start to look very, very different than if you're taking a kind of legal services provider approach, or you're taking a geographic catchment approach, or even if you're just taking a subject matter approach. I do immigration, I do labor, I do employment, I do, all of those are going to lead you in different directions than saying that my organizing principle for intake decisions is supportive movements. If that's the decision that's made, then it opens up a different set of conversations. Now, and I guess this is where I'll stop. Making that commitment in some ways just opens up another set of questions. It doesn't answer all the questions, right? It doesn't answer the questions about what the relationship is between the lawyer and the organizer. It doesn't resolve the problems that once you initiate a lawsuit, you as the lawyer now are bound by a set of ethical obligations that bring with them a logic that is hardwired into that system that you can't easily leave. It doesn't answer the question of how does a lawyer then understand the logic of organizing, which may pull in an entirely different direction. But it opens up a conversational space, not just for the one case, but instead for a period of longitudinal engagement, where I think those kinds of questions can get worked out over time. The tensions can be kind of named and illuminated. Some of them will not be resolved. They'll be kind of ongoing animating tensions. but at least they're known as opposed to things that are kind of swimming under the surface.
Muneer, you brought us into sort of the role of the lawyer, which is exactly where we want to go. But before we do, I just want to spend a few more minutes focused on the movement part of movement lawyering, which is what this discussion has been about. What I heard from the three of you in different ways is the two things that distinguish movement-based advocacy. One is the idea of necessity, right? That is, it's not a choice whether or not a deportation of an individual or a group of individuals should be stopped, right? It's not a lawyer making a decision whether to take the case or not. It's a question of movements standing up for its membership. And in the case of the Liberian program, right, it wasn't a choice as to whether or not you were going to take that on, as opposed to the way lawyers view it, which is, well, which of numerous cases might I take on? Which of numerous causes might I take on? The other distinguishing element appears to be the horizons of change, right? Muneer talked about kind of intersectional immigrant justice rather than fighting for immigrants. The way in which race intersects enmeshment in the criminal legal system is enmeshed and brings groups of people into alliance. I just wanted to see if the three of you wanted to build on those distinguishing characteristics of how movements assess moments of political possibility and feasibility. Jacinta, you've talked about how movements just assess those moments differently than lawyers do. And I wanted to see if any of you wanted to expand on that.
I mean, I'm happy to jump in. I think, you know, I frequently make the joke, like, Donald Trump never has asked their lawyer, like, can I do something, right? He always says, like, I want to do this. Tell me how I do it. What are the options? How do I figure this out? I think that the part of the secret sauce of movement lawyering is actually figuring out how organizers and lawyers can ask themselves this question together consistently in terms of figuring out how we use strategies together. Like, no organizer thinks that with one action, with one press article, with one congressional visit, you're gonna fix things. So like, why do we think we're gonna do that with law or like one litigation case or one representation case, right? Like, it is actually part of a whole. And when we're actually able to take a step back and see how we are part of a movement, right? How we are part of this bigger network of relationships and how we're contributing to building power, we understand that, like, many times the law is simply like a way of challenging norms, giving us a stage to be able to talk about what we want to talk about. And so from that perspective, the goals, the objectives just kind of shift and change. And so I think sometimes when we think of just like when you ask a lawyer, what can I do? They're giving you the parameters under what the law says right now, right? They give you kind of the menu of options of like, well, this kind of court case could do this, whatever it is. Many times what we're actually trying to do is how do we push the law to actually reflect what we want to see? How do we actually use legal tactics to shift the political dynamics to give us more power to be able to change things even further? And so I think like that is the place where like that tension has to come from to be able to push open new opportunities. And I think it both require, like, I would just say that like part of the key thing of this is relationships, right? Like we kind of forget about this. We talk about this as like, it's like transactional or theoretical, but like if we're actually thinking about taking risks together, if we're actually thinking about long-term power building together, how we relate to each other and how we like respectfully create co-strategic relationships is actually really important, right? I, as an organizer who's never gone to law school, who's not a lawyer, am on the board of Just Futures Law. It's a legal organization run by mostly attorneys, right, that are doing the work, but most of the strategizing is happening together. And that's happening because we've known each other for 10 plus years and have been in this movement together trying to figure out how to deal with some of these issues. And so I just also kind of want to highlight that because I think sometimes folks think, well, if I'm in the right legal shop or if I take on the right case, it's like, nah, find your people and actually build with them in the long run, because that's actually going to get us to a place where we can figure out how to systematically like break open new opportunities. And so I think it's a question of creativity for all of us, right? I think a lot of, I think doing work around deportations, doing work around the criminal legal system, around policing, we're constantly having to not only dismantle old structures, but reimagine new ones, right? And so I think part of this is also like, how do we create open spaces for invitation where people can actually be thinking of that strategizing and that imagining and that envisioning together in a way that is both like letting us make material differences in people's lives, right? And actually winning shit, because that's also part of what we're supposed to be doing. We're building power to actually get stuff done, but then also thinking about greater horizons and like what we're trying to build in the long run together. And I think it's important for lawyers to also know that like that is also part of your work, right? I think like having the specialty, having the skills to know how to do the footnote or know what code of law or like all of those things are really important, but also the way that we show up in relationship with each other to allow spaces to flourish that are trying to promote these types of ideas is equally important. So I think it's just also like, it's a little bit of both, right? It's like organizers trying to understand how to use the law in ways that will actually like push our movements forward. And also lawyers kind of saying like, it's okay, you don't have to have all the answers. That's not the thing here. We're actually trying to figure it out together.
Yeah, just to expand a little further. I mean, I think I wanted to talk a little bit about the dimension of time, and then also the dimension of sort of process and how we sort of get to these decisions, especially when we have to grapple with hard trade-offs, and getting beyond a little bit the sort of lawyer-client dyad, particularly when we think about social movements. I think so. One of it's definitely working with a organized base, right? Working with a membership, whether it's a formal membership or a network, or being directly sort of institutionally connected to and accountable to and responsible for grassroots members who are directly affected by the issues that we're fighting on. It can be a significant emotional burden if you're an organizer, if you're a leader of an organization, right? You feel a sense of moral responsibility, right? Every day, and it's tough. But I also think in some ways, to a greater extent than maybe with attorneys who may come in and out in their relationship with a client, it also forces us to adapt, adapt and to develop some coping skills, for the fact that we are going to have to tell people a lot of times really disappointing news, and we're going to have to be real about what we can and we can't achieve in any given moment, right? And so some of the things that I've sort of learned in having these conversations with our members over the years, one is it's sort of just to practice radical candor and honesty, right? And to be real with people when we're like, you know what, this thing that we're fighting for is not gonna give you permanent status, where it's not going to solve all your problems. It's not going to be the fix that we might want. It's going to help some people in this way and some people in this other way, and some people it's not going to affect at all. And also to not become apologists for the system, right? Like, I think we can just be real with people and be like, you know what, it is. I absolutely think that maybe after you've been here for 10 years, you should be able to automatically adjust your status. That's not how the law works. And so right now, there is no relief available for you. And part of respect for clients and constituents is both that candor, but also just sort of recognizing and affirming that on a human level, some of these things are just wrong and unjust and are a product of a broken system. And as an organizer, the next conversation is like, so what can we do together to change that? And then I think it also forces us to be real about different tasks in different moments, right? There are periods where it takes 10 years to make a year's worth of progress, and then there are periods where in a year we make 10 years worth of progress, right? This is not original observation. This is something that people in social movements have described. And there are periods like much of the last 4 years under the Trump administration where realistically what we were doing was fighting to buy ourselves time. And we all recognize that. And we're sort of like, we want to be able to have this fight legislatively under a more sympathetic administration and a better Congress. And so what we need to do is all work together and be realistic, like, yeah, that not having people deported, not having people lose status, not having people be detained for 4 years is a victory. And if we get through that to a period where we can think about bigger social change, that will be a victory. So actually, let me just stop with that. I can pick up more on some of the themes around the kind of the dynamics between organizers, lawyers, and grassroots leaders who are directly affected by those issues in a future part of the conversation.
So let me put a second set of questions on the table now for all three of you, which is the role of lawyers in movements. Again, each of you has already spoken about it to some degree, but let's dig in a little bit. So one question, what's the degree of loyalty that lawyers owe to specific individual and organizational clients, particularly in impact litigation and policy advocacy? And how do you, as a lawyer or as a movement actor trying to hold lawyers accountable, define the shifting interests of individuals and organizational clients in litigation and policy advocacy? So that's one sort of complex of questions about loyalty, the loyalty of lawyers to individual and organizational clients. And then the question is, when conflicts arise, again, all three of you have alluded to some degree, should lawyers accede to their clients' wishes, even if doing so might compromise larger movement aspirations and potentially harm others who are similarly situated? So, one example is carve-outs in policy advocacy for those with criminal convictions, which often commonly comes up in these advocacy contexts. Or alternatively, should lawyers accede to movement organizational imperatives at the perceived expense of their individual or organizational client interests, which obviously leads to a complicated ethical dilemma for lawyers who might be involved in the work. But I'm wondering if the three of you might comment on one or more of these questions and bring your own experience to bear on some of these dilemmas. And I don't know, Muneer, if you'd like to start.
Sure. So I think these are among the hardest questions. And I say that because the obligations that we bear as lawyers to clients are real. And once someone decides, I'm going to be a lawyer, I'm going to be licensed, I'm going to participate in this system, I think that you have to take those really seriously. You can't just say, I'm going to substitute, what I think the movement wants or needs for what my client does. And so this is a little bit what I was alluding to earlier about the fact that lawyering has its logics and organizing has its logics. And sometimes we get locked into those. And we may not be able to, within a period of time, get out of those. So I think what that means is we have to be really careful about how we enter into those relationships. And that brings me back to the intake conversation that we were having before. Really, to back it up a little bit more, I guess where I would start is to say that law can do some things that organizing can't, and organizing can do some things that law can't. So we should be starting from a place where we are understanding that there's a reason, right, that organizers historically have come to lawyers and said, hey, what about this? What about that? Because they're seeking certain things that are amplified through law, provide the kind of platform that Jacinta was talking about, solidify or lock into place a gain that maybe was made through organizing. Likewise, there's a reason that lawyers, and I think, increasingly, as I see, young lawyers are gravitating toward organizing. And let me just make kind of one point here. It's not directly responsive to this set of questions, Samir, but maybe just to carry forward the conversation from the last segment. One of the things that strikes me as an educator in law schools is that if you think about the kind of structure of a typical law school class, about 90% of the class discussion is going to be about what does the case say? What does the statute say? How do we interpret it? What does the Constitution say about that? It's very analytic. And then about the last 10% is the normative question. So what should it be, right? And I would say as a general matter that law students are not good at the normative piece. And I would say as a general matter that law schools are not good at training lawyers on the normative piece. There's a reason that ends up being the 10%. And I think if you look at what goes on in social movements, you look at what organizers do and how they build a movement or build a base, the normative is huge, right? It starts from a place of not what does the law say you can and can't do, but what do you think are the requirements for justice, which then requires articulating what does justice look like? What does justice feel like? It's a very different starting place. And so I think that trying to bring those two together, a kind of an analytic piece is incredibly important, but the normative kind of visionary piece is as well. And I think that's part of where there's a lot of synergy, kind of, not to say that there's no analysis, of course, to what organizers are doing. There's a huge amount as well. I just mean to say that there's a way in which I think that organizers actually are better at doing that kind of visioning piece than lawyers are. I realize that's kind of taken us off of the kind of path of like the loyalty question, but I guess what I want to say is that there is a way, I think, to both participate in these broader kind of campaigns as opposed to the individual case, a broader campaign, understanding that your mode of participation then may kind of constrain what your contribution to that campaign is. And I think it's good for lawyers to understand that. I think it's good for organizers to understand that as well, that there's kind of a shared understanding of where there is room for these two systems to kind of intersect, and where by necessity there are going to be some kind of fairly narrow channels that lawyers in particular are going to have to follow through on.
Yeah, and just to follow up on some of those themes, I mean, so having worked with sort of as a membership-based organization with some with litigators around identifying and recruiting clients, litigants for some of this impact litigation, there are all kinds of reasons why we can't include someone as a litigant, right? Because they don't have the most sympathetic case when we're thinking about what the judge and the venue is, because their facts are slightly different than the facts that are that we're trying to build a case around, because their status is such that they cannot be public, even with a benefit of anonymity, because they're just not ready and they're too scared to be a plaintiff. And so absolutely, we lawyers who are doing this impact litigation have an obligation to the specific plaintiffs and to the specific facts and circumstances and issues that they represent. But that should not be the end of the inquiry, right? And so I think one dynamic that we've been part of and that I found kind of helpful for overcoming this tension is for Ramos, for African Communities Together versus Trump, which was the DED litigation, and for some other possible litigation that we either, I forgot to mention that IRAP, International Refugee Assistance Program, was working with us on litigation challenging the African ban before that, before the change in administration happened. We have signed on both as an institutional plaintiff and helped organize and support individual plaintiffs who were directly affected by the issue, individual TPS holders or DED holders. And I think that we see our roles differently, right? Like as individual plaintiffs, their role is to say, this is how this litigation directly affects me. And to raise issues that would never occur to us. And to bring a voice of people who have the most at stake in this issue. As an organization of lots of TPS holders or DED holders, some of whom are in very different situations than those individual plaintiffs, our role is to think more broadly and to try to think about, what are some of the, what would do the most good for the most people? What helps us organize? What helps us, win the fight politically? To bring some of those other considerations to the table. And that's, it's more fluid than that, right? And individual plaintiffs all the time will be like, well, yeah, this will help me, but what, is it gonna help, Ahmed, who won't benefit from this. But I think that having both of those present, and honestly, it can be a little bit of a pain in the butt, right? Because then, especially during the last administration, we had big fights about institutional standing, right? And we had to go and sort of fight it out about why this was going to divert resources and all that, good doctrinal stuff that we, have to get into. But it was worth it because we could bring a sort of voice, and movement lawyers should be thinking about institutions and organizations as further stakeholders as well as directly affected individuals. The only other thing that I'll say on this is we have to deal with this trade-offs question all the time, not just in litigation, but in policy, right? When we're commenting on the Dream and Promise or Secure Act, right? It's all often about these kind of criminal carve-outs and who are we willing to leave behind. And we should absolutely, as organizers, as leaders in the movement ourselves, bring our judgment, bring our voices to that process. But part of our job is to convene a process and to manage that process and to make sure key voices get heard in that process, and then a little bit to trust that process. So around Dream and Promise specifically, we convened a group of our Sudanese TPS leaders and then another group of a broad, membership-based meeting to talk about the specifics of that bill, and particularly whether we were willing to sign on to kind of the latest iterations of Dream and Promise and Secure Act, given some of the criminal carve-outs. And I will always remember having that conversation with some of the Sudanese TPS leaders, two of whom were directly affected by the criminal carve-outs and would have to seek waivers and would have to fight to get permanent status because of this. And they were the ones who said, actually, we think this bill is a good step. It's going to help more people. It may or may not fix our problem, but we actually think we should go ahead and support this. And it was their voice not speaking in some ways against their own self-interest. And so, it can and should be a struggle, a political debate, but it looks very different to have that debate with the people whose lives are at stake, on pros and cons, than it does for us as kind of just to exercise our own ideological or theoretical conception of what the right outcome should be in those situations.
Cynthia, do you want to comment on sort of the process that Ahmad just talked about in terms of defining interests amongst a diverse constituent base?
Yeah, definitely. I mean, I think that these are tricky questions, right? I feel like we always get on these panels and give the 5-minute explanation, and it's like, no, behind the scenes, there's like 3 months of like hair pulling, like gut wrenching combos and processes. So I just want to visualize that because I just think that it is constantly evolving, and I think that the way that we make these evaluations is constantly shifting. I mean, I do think there just has to be a fundamental rejection of the idea that there is a conflict between collective and personal interests, right? The way that the law has set it up is already kind of actually predisposing it to say that there is a tension, that there has to be a conflict. And I actually think that there are ways that we can make sure that those conflicts come up less and less, and it is about the organizing process. I can say I've been an individual plaintiff in lawsuits. I've organized folks to do lawsuits. Like having a membership-based organization that is actually thinking about long-term campaign goals is really the strongest way to be able to think through some of these questions. And I say that because when I think of, for example, work I did again in New Orleans with the Congress of Day Laborers, when we thought about doing lawsuits against the sheriff for his detainer policy, the question was always like, well, if we just have two plaintiffs, like what's going to say that they're not just going to use it for their own interest and not for the collective, right? And so we actually had to think through what is the process to make sure that we set up the structure, that we have decision-making processes, that we're doing the political consciousness and like really unpacking what some of these things mean. Because again, with the power dynamics with attorneys, many times attorneys can come in and actually shape the conversation, right? And so I've had to kick lawyers out of the room a couple too many times precisely because of that, right? Because if a lawyer comes in and says, well, if you don't accept this carve out, then the bill's not going to pass and you're not going to get a chance to legalization, odds are they're going to say, oh yeah, let's just pass it, right? If you're saying, actually, look, what if we try to do these other 5 tactics before we accept it, it might be different. I'm not saying this is the case with Dream and Promise. I'm just sort of giving examples of like how we frame possibilities and how we frame options and how we think about the full menu and the full range of options really does matter. Because again, all of this at the end of the day is how we're thinking about risk and how we're thinking about power and how we're thinking about our relationships with each other in response to whatever we see as like what that terrain looks like. And so to me, I think it's just about, are we continuing to think about organizing over here and law over here and then trying to bring them together? That's going to be really, really much more challenging. Then again, if you have a model where you're thinking about base building as your strategy, as your vision for long-term change, and then are thinking about all of the folks that are in the orbit of that growth that are kind of contributing to continue to escalate, it just kind of comes off different. It builds different types of power, it builds different types of conversations. So to me, it's like, I've been a plaintiff and I've had attorneys tell me scary things. And I remember just being like, scared shitless and have to like go back and talk to organizers and actually come back to face my own attorneys. And I was like, it just actually goes to show how actually having collective spaces where we can be thinking about strategy makes a world of a difference. And I think that we can't think of that as separate from the process or just like superfluous. Like that is the actual work. That is the actual thing that we're trying to do. And I think that that's how we also are able to really think about, it's not just what we owe to folks that are directly impacted, but also like our movements are about bigger ideas, right? So if we're actually thinking about abolishing the system, right? If we're actually thinking about stopping deportations, full stop, is what we're doing contributing to that? Is it getting in the way of that? Where do we have that collective conversation too? And again, to me, it's a space where it has to be unpacked in a way that is like following organizing principles and allowing people to be in conversation with one another. Because if not, we actually like are setting ourselves up to have the challenges that we're trying to avoid. And so I think there's also things about just thinking about how we initiate these conversations from the beginning that can really shape, just the final result and how we continue to build.
So I just want to really support the and add to the examples of movement actors being part of litigation. And just to give us another example, in our DACA case, Make the Road New York, which is a membership-based organization, is a plaintiff. They're an organizational plaintiff. They also are a co-counsel, which adds kind of an additional layer of complexity in some ways, but richness in others. And I think just on this idea of like, what is the conversational space? The question of who's at the table, even in the litigation, really matters. And whether your litigants are there as stand-ins for the issue or are there as kind of fully realized people makes a difference. Having Make the Road New York as an organizational plaintiff helps to build out that space for our individual named plaintiffs as well. Some of our individual named plaintiffs are also organizers. And so that also really kind of enlivens the litigation space and starts to erode some of these walls between the litigation and the organizing, because we've, in a way, it's been kind of hardwired in, and that creates all sorts of additional possibilities.
I mean, you know, one thing I take away from this conversation is that interests are constructed, right? Interests aren't inherent. And the question is, how do they get constructed? Number one, they get constructed in the collective and through very good organizing, right? And two, they get constructed in the dialogues between lawyers and clients as well. So it's a dialectical process. It's not a process where clients come to lawyers and say, this is my interest, right? And Amha, you've talked about the need for resources for the organizing of both organizational plaintiffs as well as groups of individual plaintiffs who might be engaged in litigation, and the fact that oftentimes there isn't funding available to actually resource organizing. And something I've often thought is that lawyers can get out of a lot of ethical dilemmas with really good organizing. That is because they will be directed more clearly by the base that they might be working with. I don't know if you wanted to say something about that.
Sure. I mean, I think in the ideal partnership, the lawyering and the organizing really wrap around each other, right? And so I think about some of the, again, some of this litigation with deferred enforced departure beneficiaries or TPS beneficiaries that we've been part of. And, first of all, a lot of work to identify and recruit potential plaintiffs, right? I mean, and it's only because African communities together had been working with grassroots associations of immigrants from those countries, these sort of, the Sudanese in New York Association or whatever, and going and doing Know Your Rights presentations in Sunnyside or, or Bay Ridge, that we were able to identify people who would be affected by these issues. And that we had some trust of engaging those folks and being like, hey, we think you should talk to this lawyer, particularly when a lot of times their family, friends, neighbors are saying, what are you doing? Keep your head down. Don't be out there, right? Like, don't put yourself at risk. Like the nail that sticks out gets hammered down. And the whole process of getting people to a place where, we had the preliminary conversation to figure out what the facts of their case are, and whether they would potentially make a good client, and then connecting them to the attorney who then, has to go do all of that all over again. And then over the course of the litigation, partly making them feel part of a larger community, right? Like, so we had, biweekly or monthly calls with all the TPS holders, plaintiffs and not plaintiffs, where we would talk about the latest development in the lawsuit. We would talk about the latest development in advocacy for federal legislation, and bringing people through a whole process together. And that takes work. It takes an organizer. It takes, a lot of phone calls. And it's not what lawyers are particularly good at, and it shouldn't have to be their role, but it means that when people, we want to pack the courthouse, or when we want to, when a question comes up about how do we respond, in this case, like, like, what are we, not just what are we asking for, but what are we saying? What can we say? What are the issues that we can surface in response about, say, the practices for non-renewal, or, sort of, that we're able to tap into that broader network and base and support people. And, as Jacinta put it well, right? Like, it's like they hear one thing from the lawyer, but, I've been the lawyer in the room when, like, one of our members was, when I've listened to people be like, oh, my situation is such and such and such, in their own language to, like, an interpreter, but don't tell the lawyer I said that. Right. And it's like, there are different levels of trust, right? Like, because people at some, yeah, people on some level trust their attorney, but they also sometimes think of their attorney as like, the man, whether they're a man or a woman, like the institution, as representing institutional power and the government. And they have a very different relationship often with their grassroots organization that they're part of. So anyway, and actually, let me just say, and if you're ever trying to do international plaintiff recruitment, as we were trying to do with our diversity visa litigation, where we were trying to recruit applicants, that is just a whole other level of like, mobilization of resources, where we were connecting with people, in other countries, who had applied for the diversity visa program. So I just want lawyers and legal nonprofits and legal clinics and funders who fund in the legal space to be cognizant that sometimes we can't tap into the same law firm resources or big legal, the litigation funding that is like, no, we're just funding impact litigation. Part of what we need to, we need movement lawyers to do is to say, okay, we need a budget for organizing and partnership, general support for our partner on this litigation, for interpretation and translation, that those are just as important as supporting our attorneys and paralegals in preparing the briefs and the filings. Yeah, so I think that's part of what that partnership should look like.
Right. I think one of the things that should be said is that we presented it so far as movements having farther horizons and lawyers having, the harness as opposed to the force multiplier. But that's not necessarily the case, right? It could operate lawyers could be more radical than folks in the base because it's their lives, right? Which I think you've kind of talked about, all of you have talked about in different ways. So I think that's worth thinking about as well in terms of the political balance and the way, again, influence might run in both directions, not just in one direction. Okay, I want to spend a few minutes talking, really setting up Ahilan's conversation with Secretary Mayorkas in a few minutes and then in about a half hour. And to ask all of you about, again, we've established that there is a different mode of organizing and political advocacy in immigrant rights in the current context than there might have been at the beginning of the Obama administration in a similar moment. And the question is, what are, either from a process standpoint, how should the administration be interacting with movement-based organizations in building out immigration law and policy? What things do they not know how to do? They haven't done well. What things might they have done well already or have the potential to do well in? And then substantively, how might those process shifts lead to a different kind of agenda that might be undertaken at the federal level in these early days of the Biden administration? I'm sure all three of you have lots of thoughts about those questions. I wanted to see, if one of you might start in that conversation, and we can sort of talk about a policy agenda that might be more movement driven rather than lawyer and elite driven. Jacinta, do you want to start?
I was waiting to see who would go first, but totally good to jump in. I think it's important to understand this political moment within, again, its context and its history. And I think that we are coming to a moment where both the Republicans and Democrats have historically promised to take action on immigration in Congress and have failed to do so time and time again. And every time that political football begins and every time that dance begins, there's again this idea of trade-offs, there's this idea of one thing for another that has kind of led us down a really dangerous path. And we're at a point where I do think that folks are finally coming to this place of like, yes, we have to advocate for a pathway to citizenship for the 11 million. And we also have to dismantle the machinery that has been built up to criminalize, detain, surveil, and deport our people. And so this administration is walking into having to hold both. And so I think, one thing that's important for people to see is having the same speeches, having the same rhetoric around his day one bill, a pathway to citizenship, is not going to be enough to actually satisfy movements that have really been talking about openly about the racism in our policing system and how connecting that so closely to our deportation system is just elevating more injustice and creating more criminalization that has really been the motor behind the ways that the deportation machinery and detention machinery have exploded in the US. And so, I think what would it look like to have an agenda that is driven by movements is actually listening to that and recognizing that. I think one of the biggest harms that happened under the Obama administration was not only record number of deportations, but also this framework of felons, not families, right? This idea that you can justify certain deportations because of contact with the criminal legal system, because of criminal record, because of any contact with police, that should immediately justify deportation. And the unfortunate thing is, I think movements were really excited on day one to not only see the pathway to citizenship bill, but to also see the moratorium on deportations, right? Actually have an executive order that would lay that out. We know that the court stopped that, but the other thing that stopped that was actually the secretary himself writing a memo to ICE agents that said who they should prioritize and not prioritize. And in that process, instead of actually, ICE agents have we have way too many of them. They have hired an exponential amount of them under the Trump administration. They're used to being rogue and there's no accountability for them. And then they're implementing these policies that instead of giving them limits, right, or giving them rules or regulations around how to make sure they're actually assessing everyone's equities of why they should stay in their communities with their families, with their loved ones, they're actually empowering them to criminalize people based on terms that are actually designed to give them the power to further have the power of police, right? Using terms like aggravated felonies, using terms like gangs. Anyone who's done policing work knows that what that means is just one police officer saying one thing against you is sufficient to destroy your entire life. And so when you have a system that is based on that racism, that is actually profiting off of locking people up in cages and actually giving ICE agents more tools to criminalize as opposed to reining them in, it's a huge problem. And so I think for me, it's something that as movements we're watching really closely. Will the secretary actually listen to people who have been impacted by the system? Will the secretary actually invest in different frameworks and different ways of thinking about this that will actually let us reduce detention, reduce deportations? Or are they going to continue to basically fall to the right and say that anyone who's a recent arrival is a threat to national security and anyone who has contact with a racist policing system is a risk to public safety? These are faulty logics. They're actually incredibly destructive to people in communities, and they've harmed, literally thousands and thousands of lives. And so to me, I think the challenge is going to be, will the secretary take a new approach? Will they actually challenge this and do everything they can in the executive power, as well as promoting things through Congress to make sure that immigrant communities are protected? I think it's been very scary to see. There's been a few declarations for TPS, but there's many more that could be given, right? Particularly thinking about Haiti, thinking about Central America. These are folks that if there was a redesignation of TPS could protect thousands of people without need of Congress. These are things that the president could do. And yes, it's going to require some bravery. Yes, it's going to require, some politics, but it also is actually the right thing to do long-term for this country and for the people that it's going to protect. So I think that is really the challenge and what we're up against. And, I do think there's been a lot of meetings happening. We're really excited that Secretary Mayorkas is going to be on right now with Ahila and answering some of these questions. But we made an open invitation to him too to come to the Eyes on ICE forum on May 3rd. They're saying they're rescheduling, but I think we're also going to be watching really closely to see if that meeting does happen. Because again, it's not enough to meet with the lawyers of the world. You actually have to meet with the people who have gone through your deportation system, who are now in other countries because they have been deported, people who are being expelled at the border, these are the folks who have to actually have a seat at the table. And so it's going to really be up to this administration to see if they'll listen and make sure that those are factors in the way that they continue to make decisions.
Ahmad, do you want to speak to this question of process, policymaking process, and how movement orgs might have influence?
Yeah, Jacinta, I deliberately didn't want to go first so that I could just say yes, what Jacinta said to a lot of that. Just to build on some of those points, I mean, I think those of us who've been on the front lines of sort of dealing with the sort of targeting of immigrants over the last, over the course of the previous administration, know that sometimes what created the most difficulties for immigrant community members, for people who without status, with temporary status, or seeking to adjust their status, were not always some of the most visible or sympathetic or easy to explain things. A lot of it happened below the waterline. It was things like routinely refusing meritorious requests for fee waivers, routinely asking for additional information on an application that was already provided with the application. This kind of last in, first out policy in adjudicating asylum cases, right? That meant people who had been waiting 3 years to have their asylum case heard would wait 2 more years, and people who just got here a month ago would not have time to find counsel and develop a case. Immigration attorneys would not have time to, would not be able to manage their docket. So that sort of laser-like, or just the extend the, by moving resources from benefits processing to enforcement, just the way that it sort of extended the every single sort of avenue of relief that people had. So, the previous administration had a laser-like focus on preventing immigrants, particularly Black and brown immigrants, from gaining access to citizenship, right? And that is the thread that connects everything from enforcement to detention to illegalization of DACA recipients and TPS recipients, to what I think has not gotten nearly enough attention, which is shutting down avenues of legal migration and quote unquote future flows. The assault on the diversity visa program, the assault on refugee resettlement. I'm part of a book that's coming out or that just came out this week called Immigration Matters. We've got great lineup of immigrant rights organizers, lawyers, put out by New Press. So I encourage people to check that out. And I basically argue that, we need to have much more of a future flows agenda for the immigrant rights movement that's thinking about what are the avenues for people to migrate legally, as well as thinking about enforcement and mass legalization, which we need to be able to walk and chew gum and do all those things at the same time. So thinking comprehensively about the powers of, it's DHS, but it's also the State Department. We need a much more robust engagement with state around assessing country conditions and making decisions on designation and redesignation for TPS, as Jacinta said, as well as the White House. I think that all has to be on the agenda, and we need to be thinking about big, bold change, like eliminating or completely restructuring our system of immigration enforcement, and moving towards something that is more reasonable and proportional and sane and humanitarian. But all the way in the interim, we need to be thinking about all the million roadblocks that have been put up for our grassroots community members, and how do we knock them down?
It sounds like the Trump administration was, as you said, had a laser-like focus with particular policy ends in a way that no liberal legalist administration will ever have, right? What I hear and what you're saying is a critique of discretion, which was the hallmark of the Obama immigration policy making kind of complex. That is giving discretion to ICE agents, giving discretion to lawyers to make decisions about prosecutorial discretion, pull cases back. But that discretion ultimately doesn't work because of the fact that there's so many rogue agents, rogue lawyers. The bureaucracy is out of sync with political leaders. I don't know, Muneer, you've written about and critiqued the idea of earned citizenship in the context of comprehensive immigration reform proposals. Do you have thoughts on the agenda, for the Biden years and a kind of movement-driven agenda for the Biden years?
Yeah, I mean, on the process points, I think we have to kind of listen closely to people like Jacinta and Ama who are saying, here's what the priorities are, as opposed to being filtered through the lawyers or through the policy, kind of the standard inside the Beltway policymakers. I do think that, a big shift in how demands are being presented, though, is to reject certain kinds of trade-offs as being the template for getting immigrant justice done, right? So as recently as the last year of the Obama administration, we were on the verge of a DREAM Act in exchange for a massive further militarization of the border. And it was close, right? As a political matter, it was close. People were tempted. People on the left were tempted by that deal. It is, I guess, a source of some comfort and optimism to me that that's not a deal that will be put on the table now. There's been a realization and a shift away from that. And in some ways, I think it was kind of coming that close to making a deal, kind of the deal with the devil, that it's like, no, we're not going to do that. And I think that has helped to drive a kind of reorientation toward what is the vision of justice, and how do we achieve, even if we're going to achieve that vision piecemeal, how do we do it in a way that doesn't basically buy our rights at the expense of someone else's, doesn't say, doesn't kind of send future flow essentially, down the drain because we can only afford to grant rights that people are here. I mean, it's a basic conceptual difference, right? Which is, if what we're talking about truly is a justice claim, then there is no trade-off for it, right? What do you need to give up in order to have dignity? Well, that's not a conversation that we want to be having. And that's not to say that there aren't trade-offs that have to be had. That's kind of the constant tug of politics, is about trade-offs. But I do think that in some ways this goes back to whether we have and can articulate a normative vision, the left liberal vision of justice, which then provides, says, and then go execute that vision, right? Whether that's through legislation, whether it's through administrative advocacy, whether it's through use of the bully pulpit, whatever it is, you now know what it is that needs to be done. And I guess the last thing I would say on this is, and it goes back to what Jacinta said about the need for bravery. I mean, it's hard to remember this right now, but remember, DACA seemed impossible until the moment that it seemed the most obvious thing in the world, right? Now, obviously, we've spent, the subsequent 5 years litigating over the legality of it, but that's nothing compared to the way in which time and again advocates and movement actors were told, no, we can't do that. We can't do that. A bunch of people who are on this call, Hiroshi and others, helped to kind of make the legal case for why they could. But there was the political case, right? There was a political bravery that was necessary. And I guess what I would hope for, what I would encourage, is acts of political bravery, that kind of peering over the edge of what you think is impossible and doing it, and realizing, actually, you think about what DACA did and the ways in which it animated the lives of hundreds of thousands of direct recipients and the millions of people with whom they're in a relationship with. And that was a small but important move that had transformative effects. And I would hope that this administration would see that they have opportunities for other transformative moves that have transformative effect that will feel very scary to do, but that will have perhaps more support than they realize.
One thing that comes to mind is the idea of non-reformist reforms, right? DACA is maybe a prototypical non-reformist reform from the criminal legal abolitionist context. That is, it opens up possibilities rather than foreclosing possibilities in the way many of the comprehensive immigration reform packages have had in the past. Jacinta, did you want to react to anything that Muneer or Ahmad said before we move on to Q&A?
Well, the only thing I would just kind of add to this, and this is a little bit of my own, I think as organizers and as folks that are trying to do change, we're both constantly trying to dismantle things that have been created for centuries now, right? So when we think about the origins of deportation, the origins of policing, how the United States has gotten to this huge place of so much incarceration and police violence. And then we're also having to kind of have an eye for like, where are they going next, right? And so I would just, the one thing I just wanted to share in terms of this conversation of the administration and policy is, what we've been noticing for a long time with the Department of Homeland Security is that they've not only really wanted to connect more and more the policing system with the deportation machinery, but also are now adding in this whole level of surveillance, particularly with partnerships with private corporations, right, in the tech industry, that is also just kind of a new place and a new type of trade-off that we're not quite reading into, right? So because organizers have been fighting against policing, have been in the streets talking about what happens when you have a brick and mortar border wall, or you have like ICE agents in the streets, there's a consciousness of understanding that as enforcement. I think the frontier that we still have to continue to fight on is understanding that the way that they're partnering with data companies, the way that they're partnering with surveillance companies to be able to actually go around the Constitution, go around the Fourth Amendment, get information on people and become an international surveillance agency is really creating the blueprint for what DHS sees as the future of policing and which we have to see as the future of enforcement and why it has to continue to be part of our agenda. So I would just say that part of the calculus around some of these trade-offs is also understanding that, because we've seen it already with the border, right? Biden has said, I'm not going to continue to build a wall, which by the way, doesn't seem to be true, but also what we should do is invest in smart technology or the smart wall, which is actually just contributing to more of the same and actually giving police more power to continue to criminalize communities. So that's just the only thing that I wanted to add, which I think is part of the agenda of not only making sure that this administration doesn't just reverse the Trump stuff, doesn't just go to reverse some of the stuff that was built under Obama, but is also thinking about how it's building towards the future in a way that isn't actually replicating the same patterns that are, again, criminalizing Black and Brown communities.
And again, the tech for ICE, the algorithmic approaches to enforcement, the surveillance approaches to enforcement really undercut discretion, right? Which again, the liberal legalist sort of focus on discretion is completely undermined by automated systems that take it out of the hands of people who could actually constrain the enforcement bureaucracy. So that's why eyes on technological development seems essential as one of the key Mi Gente campaigns. Okay, we have a few questions and I wanted to pose the first one to the panel and see if any of you had thoughts. One question from the audience, and I encourage folks to keep posting questions in the Q&A. Why do we not see more litigation for damages in the immigration movement? It feels like this is starting to happen more often now, but some groups still will not litigate in this way. I believe, Muneer, that the Yale Clinic has done damages cases, but I'm curious if any of you have a reaction to that question.
Yeah, we have done damages cases around racially motivated immigration raids in and around New Haven. I am working on reading briefs that my students have written that we have to file on Monday, and a damages action against ICE for egregious mistreatment of an individual with disabilities, and the failure of the immigration apparatus to to actually, accommodate people with disabilities, because it's been constructed as a system to rush people out of the country, as opposed to recognizing the ways in which it actually is a long-term detention system, an incarceration system, in the way that we've been talking about earlier. So anyway, yes, we've done and continue to do some. I think one area where I know there is a lot of activity is around damages actions around forcible family separation, and a lot of those are cases where they're brought into the Federal Tort Claims Act, and so their administrative complaints have been filed. I don't know how many cases have actually been, which is a requirement to do before going into federal court. I don't know how many cases have been brought into federal court yet, but I think that, and so there is some work that's going on now. The question of, like, why isn't there more that goes on? Well, one, of course, is that damages actions for constitutional and statutory violations have been made so much harder by Supreme Court cases, and that's true for it's true for police, it's true for federal agents, it's true for ICE. They are resource intensive in a different kind of way. One thing I've been thinking about a lot in this conversation is the ways in which damages actions don't always lend themselves as well to the kind of organizing or kind of integration of organizing and litigation that we've been talking about. And so I think that's kind of another factor to consider. But I think it's a good and important question, because it essentially raises the issue of, well, what are our tools for accountability for different kinds of misconduct, and especially in a system where, Samir, as you were saying earlier, there are huge forms of discretion that largely go unchecked, and when there is institutional culture, as historically there has been within ICE and CBP, that has been undisciplined by litigation. What do we do about that? So as hard as it is, I think it continues to be an important area and for people to litigate in. And we, may need to do more in order to kind of develop collectively the tools for that litigation, and to think more deeply about how to connect it up to the kind of movement themes that we've been talking about during this session.
I think it would be, Jacinta, were you involved in damages actions in New Orleans? I know that there was a damages strategy there as well for rogue agents.
Yeah, I just to piggyback what Muneer was saying, like, what in my experience we found is, like, there's damages that can be done for state actors, and like doing 1983 lawsuits against the state, the local sheriff or the local police is a lot easier than trying to do it against ICE agents. I can also say I myself was held unlawfully on a detainer in Sheriff Joe Arpaio's jail. And it was actually really surprising for me to know that I was able to do damage lawsuits against the sheriff and was able to resolve that. But when we tried to hold the ICE agents accountable, who were actually the ones who profiled me and did all the things, all of the Supreme Court cases actually made it practically impossible. And so I actually think that's, again, like one of those times where we, like, I sometimes think, should we just do a lot of those and just lose, just to show that we can't, to get Congress to do something? Who knows what the strategy could look like there, but it has made it incredibly challenging to just, take on those types of cases, given those limitations.
Right, I completely forgot that it was somewhere in my memory that you were a plaintiff in a damages action in Arizona, but that's right. It wasn't New Orleans, but it was both, I guess. I wanted to, we didn't get to the fourth part, and I wanted to put it here for some brief responses with regard to sites for the development of movement lawyers. And again, each of you is working in really powerfully generative sites. And so, Jacinta, you are on, as you mentioned, on the board of Just Futures, which is a kind of new startup that has the capacity to create a generation of movement lawyers and immigrant rights advocacy. Muneer, of course, you're involved in clinical legal ed and are training lots of lawyers. And Amaha, you've created an NGO that has both an organizing and legal capacities. And so maybe starting with you, Amaha, what would you say about again, nurturing movement lawyering and this kind of sensibilities that we've been talking about in the course of this conversation? What are some maybe some of your hopes for creating such sites?
Well, I think in order to develop more of a sort of a team of movement lawyers and sort of a culture of movement lawyering, I think we need to break down some of the siloization that happens in the legal profession and some of the sort of thinking about what is lawyering. So I started my organization, so I actually had a career as a organizer and leading a community-based organization for a long time. I went to law school late, and I already knew that the reason I was going to law school was to start African communities together. When I came out of law school, I applied for resources to start African communities together, and ultimately I got this fellowship, Echoing Green, that was the launch. I had terrible success or sort of experiences with trying to raise funds from traditional legal funders, from legal fellowships, right? Like I think, the idea was like, well, why would you want to start a national membership organization of immigrants from Africa? Why don't you just do like one legal assistance project in one neighborhood dealing with people from one country? Like, this is so big and broad. We just don't understand how it's lawyer, and it doesn't seem very legal, right? It doesn't seem like you're lawyering per se, right? Like, and to which my response was like, yeah, it's big because the need is big, and the opportunity is big, and traditional legal services are going to be one part of our strategy, but they're going to be a gateway to building membership in the organization and developing leaders. And still a very small, and even now that we're like a relatively large national organization, sued the Trump administration 4 times, have done hundreds of sort of immigration legal services every year. We are traditional legal funding, particularly outside of local government, which has supported that work, is a really small part of our portfolio. We don't have an equal justice fellow. We don't have some of these traditional things that other more sort of squarely legal service providers rely on, and it's a source of infinite frustration to me. So I will do a plug. We are hiring a national legal director and a director for our New York, a supervising attorney for our New York office. I will drop the link in the event chat. So send us good people, and part of that person's role is going to be to help develop these legal partnerships. But there's been a lot of, especially running a Black-led organization, like a Black organization, over the last year, since the uprisings last summer, there's been a lot of lip service to supporting Black-led organizations, and mostly it's been lip service and not actual resources moving. So some of it is just, we kind of need legal institutions and our potential partners to say, who have stable funding sources or tap into broader, sort of institutional funding or law firm funding, to actually figure out how we get movement lawyers who are part of movement organizations. And that's part of what we need. And that can then create opportunities for those rising law students and those, people who've had a little bit of firm experience and want to put that to work in a movement organization to have places to land.
I'm afraid that I have driven our conversation to the end of time, and so I can't circle back on just futures and the clinical context, but they're there, and Muneer and Jacinta are doing great work with new lawyers entering the field. And so thank you very much to the three of you for this super generative conversation. Appreciate it very much, and I'm going to hand it back to Ahilan.
And just to say thank you all so much. That was amazing. I feel like it should be required viewing for anybody working in social justice lawyering and students, and not just students. I have to say, I'll admit to this in this moment. I'm one of the lawyers who Amaha mentioned, who, I had a lot going on, in fairness. I had 2 other TPS cases going, but I was like, I don't know about this Liberian DD thing. I'm very glad that Ora Nimni and others had a different view of it, and it worked out so well. But seriously, thank you all so much. That was an amazing discussion. I really appreciate it. And to all the people out there listening, we're going to bump you off now in just a minute. The webinar will end, and then you'll log back in a few minutes before to see the conversation with Secretary Mayorkas. So thank you all again.